Foreign equivalence doctrine may not apply to trademarks that combine English and foreign words. The U.S. Patent and Trademark Office's Trademark Trial and Appeal Board has ruled that the doctrine of foreign equivalence is a guideline rather than an absolute rule and may not apply to trademarks that combine English and foreign words. DBMG sought registration for the mark Sunset Sushi for bar services, Japanese restaurant services featuring omakase. The application disclaimed the word sushi. The mark was described in the application as a circle containing the words Sunset Sushi, stacked in an uppercase stylized font with a stylized depiction of an island to the right with 3 palm trees and a seagull flying overhead, all over a background gradually transitioning from being lighter at the top to darker on the bottom. The trademark examining attorney refused registration of applicant's mark under Section 2D of the Trademark Act, 15 U.S.C. Section 1052D, based on the prior registration of a mark for Banshu Sushi Bar, with Sushi Bar disclaimed, which also incorporated a sunset. Also, an English translation of Banshu is sunset. However, a native Japanese speaker submitted a declaration that the modern term for sunset is Nichibotsu, not Banshu. Under the doctrine of foreign equivalence, foreign words from common languages are translated into English to determine similarity of connotation with English word marks. According to the board, the examining attorney argues that the doctrine of foreign equivalent applies because Banshu translates as sunset from Japanese, and the average purchaser would stop and translate. The board noted that Section 2D of the Trademark Act prohibits registration of a mark that so resembles a registered mark as to be likely, when used on or in connection with the goods or services of the applicant, to cause confusion, or to cause mistake, or to deceive. The board noted that the doctrine of foreign equivalence generally has been applied when the wording in one mark is entirely in English, and the wording in the other mark is entirely in a foreign language. In this case, the cited registration is for a combination of a Japanese transliteration, Banshu, and the English words, sushi bar. The board found that the doctrine of foreign equivalence didn't apply in this case. Consumers will not stop and translate the portion of registrant's mark that contains a Japanese transliteration, but will take the literal portion of registrant's mark, Banshu Sushi Bar, in its entirety as it is. The takeaway here is that it may be possible to avoid the doctrine of foreign equivalence if a mark combines English and foreign words, especially if the design elements of the marks are significantly different. Need help with your brand? Book an appointment with us at www.eonlaw.com. Eon Law. Unleashing Genius.